You're listening to Workplace Perspective, an employment law podcast presented by Sapphire Legal. Workplace Perspective is a regular podcast series for employers and employees focusing on education, training, and the law to help organizations of all sizes develop and maintain successful workplace relationships. The opinions expressed by guests on Workplace Perspective do not necessarily reflect those of Sapphire Legal or its attorneys and should not be considered legal advice. And now, here's your host, founder and principal attorney at Sapphire Legal, Teresa McQueen.
Thank you, James, and welcome everyone to Workplace Perspective, where we are striving to raise the bar at workplaces everywhere. On today's show, we'll be talking with bankruptcy attorney Harlene Miller about some key issues when it comes to dealing with bankruptcy in the workplace. Harlene's going to walk us through a few bankruptcy basics and then discuss with us some key areas of concern when it comes to bankruptcy for both the employer and the employee perspectives. It's going to be a great show. Don't go away. We'll be right back.
The opinions expressed by guests on Workplace Perspective do not necessarily reflect those of Sapphire Legal or its attorneys and should not be considered legal advice. You're listening to Workplace Perspective, an employment law podcast presented by Sapphire Legal.
Welcome back to our listeners and welcome to Workplace Perspective, Harlene Miller.
Good afternoon, all, and thanks, Teresa, for this opportunity. I've been an attorney for 29 years, practicing solely in bankruptcy law. 22 of those years as a certified specialist in bankruptcy law, which required a second bar exam. I represent creditors and debtors, those filing bankruptcy, so I have gained a perspective from both sides. All types of bankruptcy filings, litigation, as well as financial workouts outside of bankruptcy.
Well, that's awesome. That's a stellar career. How long have you been practicing?
29 years.
29 years.
I know.
Always in bankruptcy?
Always in bankruptcy.
That's awesome.
I love it.
It's an interesting area of the law. You know, I was thinking about bankruptcy and the workplace, and it really struck me how, from an employer-employee perspective, they really do have, the employer and the employee have a really symbiotic relationship, right? So it's the employer's job to pay. It's the employee's job to work and perform so that the employer can earn money to pay them. So when either side of that equation sort of falls down on the job, so to speak, it really impacts the other, right?
Absolutely. Financial issues and bankruptcy impact on so many areas of personal and business lives. It really does.
It's amazing. And the only real experience that I have with it is that from a litigation perspective. So from a perspective of, you know, plaintiff, we filed a lawsuit, company goes bankrupt, and then we have issues. So I'm really excited to learn more about the impacts of bankruptcy on the workplace. And to give us some context before we start today, can you walk us through the various types? Because I know everybody talks about chapters, and there's all these numbers related to it, but I'm never sure in my head exactly what they mean. So can you briefly walk us through that?
Absolutely. First of all, bankruptcy is federal law. So the bankruptcy code and related rules are the same for all states, although often interpreted differently by the case law. The code itself identifies bankruptcies in chapters. So Chapter 7, which most people have heard about, is usually filed either by individuals or businesses. For individual purposes, the fresh start is there for them. They get rid of debt. Hopefully they keep their assets. For businesses, the result is liquidation and closure of the business. So it's very different between personal and business, Chapter 7. Chapter 11 is reorganization, most common heard about in the news. Reorganizations usually are businesses, although individuals can file them as well. And the purpose is to allow the business time to reorganize and do a plan of repayment to creditors while continuing to operate the business. Chapter 13, individuals only. It's a very unusual type of bankruptcy, and it is like a mini reorganization for individuals. It allows them to propose a plan of repayment to their creditors over a maximum 5 years. And it's very helpful where there are arrears due to mortgages or taxes that are due, and those creditors are unwilling to accept payments that they can afford.
So it's not a wipeout.
Well, no, it's not a wipeout in that term. There are payments made to creditors, usually not 100%, and at the end of the case, a discharge is granted for whatever has not been paid. So it's a very unusual type of bankruptcy. We do have 2 more chapters. We've got Chapter 9, which are municipalities. And most of us here in Orange County, depending upon how long you've been here, have heard of the County of Orange bankruptcy, and that was a Chapter 9. There was also a recent, or not so recent, bankruptcy for the city of San Bernardino, also a Chapter 9. And our last one that we don't see too much here in Orange County is a Chapter 12. It's for family farmers or fishermen. So it's a reorganization case, and like I said, not often seen here. Although when I first started out, so many years ago, our firm did have a Chapter 12 for a owner of strawberry fields, because Orange County was covered with strawberry fields at one time.
That's right. That's right.
Yeah.
So much of that farmland's gone. Oh, it's so
right.
Sad. It's so sad. Well, I was going to make a joke about the price of fish.
No.
So I won't do that, about how to possibly go bankrupt with the price of fish. But I'm not going to go there. So so we know employers and employees, so individuals and companies and municipalities. I've just totally forgotten about that. And you told us a little bit about the purpose of that. Let's jump right into it. How does a bankruptcy typically impact an employee? Let's start with that perspective.
Okay, well, first of all, you need to understand what happens when a bankruptcy is filed.
Oh, well, tell us about that.
There's an automatic stay that goes into effect, and that's probably the most powerful part of a bankruptcy. The automatic stay is like an injunction. It stops creditors from trying to collect from the person or business that filed the bankruptcy. And it's immediate. As of the day, the hour, and the minute of filing that case, because it stops foreclosures, it stops garnishments, it stops levies. Very, very important aspect of bankruptcy.
But does it matter what chapter?
Doesn't matter what chapter. There's always an automatic stay.
Okay. All right.
So, and it's in place even if the creditor hasn't received notice yet. It's based on the day, time, and minute of the filing of the case.
So everything goes back retroactive. So when you get notice, it might be 2 weeks after the filing, and then it's got to go back, right?
Won't be that far away, but yes, it's as of the date of filing.
Okay.
Right.
All right. So what else does an employee need to know besides they need to know about the automatic stay? What else do they? What else is important to them?
If an employee is filing bankruptcy, obviously the automatic stay for the employee is very important, because oftentimes there is a wage garnishment in place where perhaps they were sued and a judgment was obtained by the creditor, and the power of those judgments provides that creditor more ways to collect the debt. And this is outside of bankruptcy, okay? So they can levy on bank accounts and they can garnish wages. So that employer is noticed to garnish that employee's wages, and obviously it's a huge impact on the employee. Filing bankruptcy immediately stops the wage garnishment. So in terms of that particular issue, it's important for the employee also, and it's important for the employer to know that as soon as they receive notice about a bankruptcy, they must immediately stop garnishing the wages.
Interesting. I get a lot of calls about garnishments. People get very confused about what to do about them. Can I ignore it? Do I have to do it? Yes.
Have to do it.
You have to do it.
And
it's an order.
When you hear about bankruptcy, as far as the employer, you have to stop doing it.
Interesting. All right. Well, that's good to know. So what happens when an employee files a bankruptcy just in their personal life? Can it impact them in the workplace? I think a lot of people have concerns about that, because they feel like, is somebody going to know? Is everybody going to find out? Am I going to be penalized for that?
It is of concern, obviously, for anybody filing bankruptcy. And I often tell my clients that are filing a Chapter 7, we don't put a big giant B on your forehead that you filed bankruptcy. Unless you share that with someone, The only people that get notice of it are their creditors. And yes, there may be a personal loan or a loan from Aunt Susie who has to be listed. But other than that, it's not published in the paper anywhere, and people just do not know about it.
You may have mentioned this, but did you say, so if an employee files a bankruptcy, is there anything that could come besides the wage? So if there's a garnishment or something like that's important, but depending on what chapter they file under, could the employer find out? Could the employer be required to take part of that pay? Like, is there a garnishment or something like that?
Not when an employee, well, when an
you know
employee...
what I'm trying, you know what I'm getting at? Like a garnishment, but not a, well, maybe it is a garnishment. I don't know.
If an employee files and there's a garnishment in place with the employer, it stops, period,
Right.
the end. There's nothing else that impacts that relationship. If a individual files bankruptcy, it's against public policy to fire a person because they filed bankruptcy. It's against public policy not to hire someone just because they have a bankruptcy in their history. And so, except where maybe the individual employee is dealing with cash or payroll or maybe working for a bank. That might be a sensitive issue with that kind of an employer. But otherwise, there is no other impact in terms of the employee-employer relationship.
Okay. Yeah, I knew about the public policy. I think that's interesting. It's, we always talk about employment law. We talk about public policy against the state of California, but this is federal, so it's against the public policy of the United States to retaliate or discriminate against an employee who has filed a bankruptcy.
Right.
But I think what I was getting at was is there any way for a creditor to collect a debt by attaching wages?
Not after a bankruptcy.
Not after the bankruptcy. Okay, so that's what I was.
That's where
kind of
we
what I was
go
thinking.
back to the automatic stay that stops all collection
Oh, okay.
effort.
Okay. Well, from a workplace perspective, what are some of the things that might be a warning sign for an employee to look at? Because we're going to start talking about the employer aspect of it, but in a workplace context, not from the employee filing, but the business is in trouble. What some things that the employees should look out for?
Well, usually what they see first is there's a delay in getting paid. Their wages are held. Either there's a week delay or perhaps there's even a couple-day delay from the norm. And I think all employees have to be cognizant of this, that even if there's a very brief delay and it hadn't happened before, that this is something they need to keep their eye out for. Obviously, the business itself, hopefully, maybe it was just a blip. Maybe they didn't receive anticipated funds timely. But it's important for employees to keep eye on things like this. If it happens multiple times, then obviously they probably would want to try and speak to a supervisor. They might want to talk to other employees to see if other employees are not receiving their wages as well. Because a sign of late payments to employees is a sign of potential financial crisis for their employer.
Absolutely. All right. Well, it's sort of the one question we don't really have a lot of time to answer, and kind of the elephant in the room would be that, how long should I stay after I see the warning signs? But it's such a personal decision. I don't think we can really say too much about it other than to, you have to make a decision and weigh those checks and balances. Is the loyalty worth getting yourself into financial debt? But I think you made a good point about keep an eye on it. If it happens more than once, then that's a bit of a sign you might want to start really looking hard at this and maybe having some hard conversations with the employer.
And also looking around for other jobs on
Right.
the quiet, that it's not something you need to discuss with anyone, even your fellow employees. Protect yourself, protect your family, protect what income you need to support your family.
Good advice. All right. Well, we're going to take a quick break. And when we come back, we're going to look more specifically at bankruptcy from the employer perspective. So stay with us. We'll be right back.
The average time a resume spends on an HR manager's desk is 7 seconds, and most of them are tossed aside. Now imagine if one of those resumes belonged to Yasmin, who was
living in a shelter, juggling 3 jobs. I had to be resilient. That's something that you can't teach.
or if that resume was from someone who
Worked 12-hour shifts at the recycling company with my dad, who's 72. That taught me a work ethic that I carry with me every day.
We rely so much on a resume, yet it could never tell the full story of someone.
Growing up where I did, a lot of things could have gotten in the way of my goals. But I learned to push through, and that's what I bring to work every day.
So maybe it's time we look beyond the resume and look to Grads of Life. Discover new ways to develop great talent that are so much more than what's on paper at gradsoflife.org. A public service announcement brought to you by Grads of Life and the Ad Council.
Here we go.
Welcome back. We're talking about some important need-to-know information for employers and employees when it comes to bankruptcy with attorney Harlene Miller. Harlene, let's talk a little bit more specifically about the employer's perspective. Seems kind of obvious to say, but I would think the main focus for an employer would be staying out of bankruptcy and avoiding the fallout from bankruptcy proceedings of other people that they deal with. But in your opinion, what is typically the employer's main concern when it comes to bankruptcy?
The filing of a bankruptcy for an employer is a difficult one because the filing of a bankruptcy, and in most cases we're talking about a Chapter 11 reorganization where they just need time to hopefully reorganize, get new projects, reorganize, maybe reduce expenses, and the goal is to keep the company going. But the problem with filing a Chapter 11 is that all of the creditors, all their vendors, all their suppliers who are owed money get notice of the bankruptcy.
But the Chapter 11 is the reorganization. So business, they keep making money. They keep doing business, right?
Right.
Because this is a chance to just reorganize and catch up. Okay.
Yeah, reorganize, do a plan of how the old clients are going to, all the old creditors, are going to be paid. The automatic stay goes into effect. It freezes all the debt that the company owes as the date of filing. And the goal of the 11 is to work through this process, see how they can project income, and propose this plan of repayment. So the difficulty they're faced with is vendors may not be so willing to deal with a company in a Chapter 11. They don't know if it's going to survive or not. And if they're providing supplies or services, they've already got a debt that's frozen and can't be paid. They may not be so willing to do that. Many of them will demand COD, cash on delivery, which affects the company's cash flow, obviously. And other than that, the company's got to look for other resources for getting vendors or supplies or anything else. So it is a difficult process.
And so in a Chapter 11 situation, they're not creating, how do they deal with creating new debt? So if it freezes everything in place, how do they go about, how does that work if they're, because they're operating, right? So aren't they in essence creating additional debt?
They're not supposed to be.
Oh, well, how does that work?
This is how it works. Ideally, if the company isn't paying or servicing that old debt, now they can operate as if it were a brand new company with no debt. Anything that's incurred while the Chapter 11 is operating, any business debt has to be paid as it's incurred under whatever terms they can get with these creditors. So it's a regular operating company, but it can't incur new debt on top of what's already been frozen by the Chapter 11.
Interesting.
And unfortunately, a lot of times the analysis isn't done sufficiently to see if this is a viable enough company to do a Chapter 11. Oh. And if it isn't, and they can't maintain their expenses and they can't proceed timely with the plan of reorganization, the effect is conversion to a Chapter 7, which is liquidation of the company, and the company goes out of business.
Well, who makes that decision?
Well, oftentimes it's the court and the Office of the U.S. Trustee that oversees these cases will be monitoring how this company is doing, how the finances are. They are provided reports every month on income and outgo so that they can see, well, this looks like maybe they can work, and they've got to do a plan within a reasonable period of time. And if they linger too long in the Chapter 11, the Office of the U.S. Trustee is going to file a motion to dismiss or convert the case. Oftentimes, The debtor's counsel, which is also a bankruptcy attorney who's there to protect this company, will monitor these things as well and have very, very strong discussions with the owners of the company that this isn't working. I don't see any progress. I don't see how you're going to do a plan of reorganization and make a recommendation as to what to do from there.
Now, I might put you on the spot, but it just occurs to me, so if that's the case, what if it was like some huge company that was a huge employer, had a big impact on the economy, if it were to go under, whatever. When they're making those decisions, do they take that stuff those types of issues into consideration, or is it more or less about kind of the things that you mentioned?
Well, I'm not sure who the they is that you're referring to, but
all of the they,
the theys,
the people that people looking at it and making those decisions as to whether or not this should be a Chapter 11 or a Chapter 7.
Yeah, by and large, it's the company itself, it's the bankruptcy attorneys and advisors, it's the Office of the U.S. Trustee. And yes, it does hurt. It hurts any company that closes and can't continue. But the decision, just because, they're employing so many people, we can't let this happen, where are you going to get the money to do a successful Chapter 11? That's the bottom line here, unfortunately.
That's interesting. What an interesting analysis. Well, can you tell us, so are there any specific tips for employers?
Tips for employers: be on top of your accounts payable. Be on top of your accounts receivable. Even if people are paying fairly on time, you should be monitoring these all the time. You should have someone who is really watching these. Try and get better terms from people who owe you money or you owe them money, so that it helps with the company's cash flow in the slow times. And also doing your due diligence on who you're providing credit to. It's not necessary to give everybody 120 days to pay. That's a huge period of time for a company.
Yeah.
So it's really important to keep monitoring this. And just because you've had some good times, you should still be constantly monitoring the money coming in and the money going out.
Okie rich, as we call it in my family. All right. So in our remaining, I think, minute or so, can you share with our listeners your 2 biggest takeaways from today's program?
Well, one that I didn't mention was don't be afraid, either employee or employer. If things start going bad or if you are uncomfortable about something, consult with a bankruptcy attorney. Many of us offer a half-hour no-charge consult, and it's not a lot of time to just get the information you need for a company kind of feeling that, gee, things aren't going too well. Get an analysis from a good qualified bankruptcy attorney so that it's not we have no choice, that you've got time to think, time to plan.
All right. Well, that's our show for today. Harlene, I want to thank you so much for coming on and joining us.
Thank you.
It was some good information, and I think it's gonna help people out. And I just thought it was kind of informative. I didn't know much about bankruptcy, and now I know that much more. So if you want to learn more about Harlene's bankruptcy practice, you can find her on the web at harlenemillerlaw.com. That's HARLENE millerlaw.com. You can also connect with Harlene via our website at sapphirelegal.com/podcast and click on episode 10. I want to also thank our listeners and my radio angels, James and the Knave at Night, and as well as Workplace Perspectives team extraordinaire, our engineer and producer, Paul Roberts, with our music provided by the very talented Stephen Versaloni. I want to thank you all for joining us on Workplace Perspective, and until next time, keep raising the bar.
There we go.
Imagine what it would feel like to lose everything. Your job, your home, your family, your dignity. This has happened to thousands of the men, women, veterans, and young adults we serve at Working Wardrobes. What do we do to help? We provide career development services, life skills workshops, job skills training. We provide the perfect interview outfit, and we get clients placed in jobs. Call Working Wardrobes, 714-210-2460. Donate, volunteer, invest. higher.
I think that was good, and bankruptcy is certainly one of those.
Live from NPR News in Washington, I'm Jack Speer. The worst of Hurricane Michael is now moving through the Florida Panhandle. Michael remains a still strong Category 3 hurricane as it moves inland with torrential rain. Dolores Hinckley from member station WUFT is inside the Emergency Operations Center in Panama City, Florida.
Michael's winds are battering the Emergency Operations Center here, but work continues. Bay County Emergency Services Chief Mark Bowen reiterated what we've heard many other officials say. They're worried not enough people got out based on shelter tallies and evacuation orders.
There are people out there in this storm, and it's just physics and common sense that there's going to be some situations out there that could be unsurvivable.
A mandatory curfew is now in place from dusk until dawn. For NPR News, I'm Dolores Hinckley in Panama City.
The Justice Department is charging an alleged Chinese spy with economic espionage and theft of trade secrets. As NPR's Ryan Lucas explains, a suspected Chinese intelligence operative was extradited from Belgium to the U.S. to face charges.
Yan Zhenshu was arrested in Belgium in April and extradited to the U.S. this week. He faces 4 counts, including conspiracy to commit economic espionage and steal trade secrets. Xu has now made his initial appearance at federal court in Cincinnati, Ohio. Court papers say that Xu works for China's Ministry of State Security. He allegedly targeted a range of aviation and aerospace companies, including GE Aviation. Xu invited experts and engineers to China under the guise of making university presentations, but in fact, prosecutors say the trips were part of an effort to steal sensitive proprietary information. U.S. officials say Xu's actions are one aspect of what they call an organized and relentless campaign by the Chinese government to steal U.S. technology and innovation. Ryan Lucas, NPR News, Washington.
The White House says both National Security Advisor John Bolton and Senior Advisor Jared Kushner have spoken to the Saudi Crown Prince about a missing Saudi journalist. Press Secretary Sarah Sanders confirming the discussions today in regards to Saudi journalist Jamal Khashoggi. He was last seen entering the Saudi consulate in Istanbul, Turkey. Turkish officials say they believe Khashoggi was killed, charges the Saudi government's denied. Wall Street hasn't seen a sell-off like the one today since February. All 3 of the major U.S. stock market indices falling 3% or more. Diane Swong, chief economist at Grant Thornton, says some investors appear to be concerned about how pricey tech stocks like Apple and Amazon have become.
We hit, a point where all of a sudden you had 2 major tech stocks cross $1 trillion in value. And all of a sudden that, reality slipped a bit today. The ground shifted.
Apple dropped 4.6%, while Amazon and Microsoft both fell more than 5% today. The Dow dropped 831 points. That was a decline of 3%. The Nasdaq fell 315 points. That was a drop of 4%. You're listening to NPR. NASA's big new rocket is costing billions more than planned, and it will likely miss the current target window for its first launch. That's according to an audit by the agency's Inspector General. NPR's Nell Greenfield-Boyce has the story.
Since the space shuttles were retired, NASA has been working on the Space Launch System, a massive new rocket for sending up both astronauts and science missions. To build it, NASA contracted with Boeing. An audit by NASA's Inspector General now projects that Boeing will spend at least $8.9 billion through 2021, double the amount originally planned. And the project is more than 2 years behind schedule. The audit blamed both Boeing's performance and NASA's oversight. NASA says that it and Boeing are well underway in implementing the report's recommendations, and that the agency continues to plan for a